And for 27 years, 66-year-old Bonnie Foreshaw has sat in a prison cell, convicted of murder. She was convicted that she shot and killed a pregnant woman decades ago, and that is not in any doubt.
But many have questioned whether her sentence was too harsh. News 8's Ken Pierce joins us from the New Haven newsroom with details and expert opinion on a hearing that could set her free. Ken?
And Aaron and Chris, at this hearing today, Bonnie Foreshaw is going to ask for her sentence to be reduced to the 27 years she's already spent behind bars. Now, there's going to be a lot of talk today at that hearing about the abuse that she suffered over the years. For one thing, she was raped and had a baby at age 12. She was abused by 3 husbands. An ex-husband was stalking her in March of 1986, so she had a gun when she went to a Hartford bar one night. A man in that bar started harassing her. He followed her into the parking lot. Foreshaw says she thought the man was going to assault her, so she got the gun and pulled the trigger. But the bullet hit a pregnant woman named Joyce Amos instead. Amos had stepped in to try to defuse the situation. She died. Foreshaw was convicted of first-degree murder and sentenced to 45 years in prison. Joining me this morning is Quinnipiac University Law Professor Bill Dunlap. Step on in here, Professor, and tell us, I've always thought that a murder conviction and charge had to imply there was intent, and nobody thinks that Bonnie Foreshaw intended to kill Joyce Amos, right?
I think everybody agreed she didn't intend to kill Ms. Amos, but there's, I think, a lot of evidence that she intended to kill the man. And in the criminal law, there's a doctrine called transferred intent that says if you try to kill one person and accidentally kill another, it's still going to be regarded as intentional murder.
There's still a lot of people who think she should only have been charged and convicted of manslaughter, however. Why is that?
Well, I think there's a fair amount of evidence there that she may have been acting under extreme emotional distress at the time. And while that's not a complete defense, it would reduce a charge from murder to manslaughter, which carries a far shorter prison term.
There was a memo written in 1989 by another public defender criticizing her public defender for how he did his job. What was the criticism? What did he not do right? And I think it has a lot to do with what you're talking about, that mental state of hers.
Apparently, the lawyer who handled the case at trial did not put in evidence regarding her mental state, did not present evidence for a lot of the defenses or partial defenses that would have been available. And so another public defender who's now a judge in Connecticut wrote this memo excoriating the trial lawyer.
You think that's going to pull some weight with today's hearing?
Apparently it already has, because she requested a hearing several months ago and the clemency was denied. But now, once the memo came to light, the board has said, we'd like to hear this case again, which is extremely unusual because it actually says on the Board of Pardon and Parole's website, we are not here to hear complaints about ineffective assistance of counsel, and yet once they heard about this, they've decided on their own apparently to take the case.